one else was in the room where it happened, the room where it happened, the room where it happened. No one else was in the...
All right, welcome back, ladies and gentlemen. You've taken a look at the introductory video for our class in which the overall arc of the syllabus was explained to you, as well as the methods that we're going to use in order to do our partially asynchronous and partially synchronous discussion-based class. So this now is the first asynchronous lecture video for you. For this lecture, you've read Federalist 78 and you've read John Marshall's decision in Marbury versus Madison. If you haven't read them yet, I'd really recommend that you stop this video right now and do the readings ahead. Now, that may not be necessary for each week of the semester. Sometimes it might actually help to watch the lectures, then do the readings. It's something that you can decide on yourself. Or in other words, sometimes you might actually want to hear the concepts that I'm lecturing about in the readings and then see if you can pick up those concepts yourself as you read. If you do it that way, be sure also to be on the lookout for concepts I don't cover in case you want to engage in debate about those concepts when we meet synchronously. For instance, you might actually find in the readings some evidence that they mean something different or something more than what I say in our recorded lectures. And that's important because any lawyer, in order to argue for their client, will have to be able to look at the same law, the same bit of text, in other words, and find a different case to make about it than their opponent is making in court. So you should always be on the lookout for alternative interpretations of any legal text that you read, perhaps any text that you read. And I'm going to do my best to show you in each of our recorded lectures a few different ways of thinking about each of the readings that we do this semester in order to prompt some discussion and some debate in our synchronous classes. But you should also be asking a lot of questions about alternative meanings yourself and how different meanings might actually suggest different conclusions, like for one client or for a very different one, for instance. So no matter what, have the readings done before we engage in our synchronous discussions with each other, our live discussions, because then you're going to be asked to take a stand on the meaning of the readings and how they apply to different cases or to different clients. So you're going to need to know the readings and the main principles in them by the time we meet synchronously. But this time, for this particular lecture, it's necessary to do the readings ahead of this video. I want you to notice the difference between the concepts that you pick up in the readings without yet knowing what the major questions of the course are, and the concepts that I focus on in this lecture. And that's going to help you to notice, if you do the readings ahead of time, that's going to help you to notice how it is that as the semester goes on, an increasing focus on the sorts of questions that you want to answer in this class will actually help you decode the importance of the readings and decode the importance of these lectures as well. So, if you haven't done the readings yet, stop this video right now, go to those readings, give them a try, and write down what you think the major concepts of each of the readings are and how you think they might actually differ from each other in subtle ways. Then come back to this recording and see if my analysis of the major themes matches up with yours. Okay, so go ahead. I'll be right here waiting for you. Okay, are you back? Good. Now, you've read Federalist 78 and you've read Marbury versus Madison. It's ordinarily understood by everyone that these pieces both justify judicial review. But what we're going to see in this video is that among all the American founders, really all of them might have wanted judges to have at least some sort of power to review some sorts of legislation, but they very, very much disagreed about how much power and how much legislation should actually be under that power. So most of the founders thought and hoped that judicial review would be quite limited. So for all of the founders that we read, be on the lookout for which problems they thought judges should and which they thought judges should not be addressing through the power of judicial review. So to get a sense of what those various different powers might be, take a look at this graphic. It covers what problems judicial review could and could not address. So for instance, 1, the federal government might do 3 things. It might violate separation of powers or checks and balances. It might violate the powers of the states, or sometimes called states' rights. Or it might violate individual rights directly. Second, the state governments might also do things that courts could review. They might, A, violate the interests of the United States as an entire entity by doing a couple of different things. It might usurp federal powers, the United States government, or it might damage the interest of other states, therefore damaging the union between those states. Or it might be violate individual rights directly. Okay, so now back to Federalist 78 and Marbury versus Madison. While we're going to see that Hamilton and Marshall actually focus on powers 1A and 1C in our outline, so that is the power of the court to block the federal government from violating separation of powers, and to a certain degree, to block the federal government from violating individual rights, there's no mention in either of these readings about blocking the state governments. So be on the lookout for that question of reviewing state actions as this semester goes along. What we're going to see is how the Supreme Court only very slowly actually took upon itself the power to review state actions. Marshall did some of this in some of his later decisions, that is after Marbury versus Madison, but that power to block state actions really grew much later. And Hamilton, you'll see, barely mentions it at all in Federalist 78, because the truth is that most of the founders were vehemently opposed to the idea that the Supreme Court could block state actions. Hamilton had to be very careful in this Federalist paper to say that the Supreme Court had the power to do 2 things that it should do: protect separation of powers and sometimes protect individual rights, but to say also, or at least to imply, that it did not have the power to meddle with the states. And he also had to emphasize that the court would not be powerful enough to lord its power over the federal legislature, which most of the founding generation thought should be the supreme power in the federal government. Marshall, perhaps not surprisingly, since he was the head of the Supreme Court once it got started, was much less reluctant to claim that the court had the power to block federal legislation, to block that federal legislature. All right. So what you get in these readings is a mix of very similar sounding arguments, but Marshall's arguments tilt far more towards the power of the court to be supreme, or we could say superior, over the other authorities within the federal government. And so a lot of modern day opponents of the court look back at Marbury versus Madison as the beginning of what they think is a long descent towards judicial supremacy. That is, the Supreme Court's belief that it is in fact the superior authority on all of the questions that come before it. Okay, so listen up. What I've done is I've put on classes in the handouts folder color-coded versions of these readings. So each of the concepts that I want to highlight in this recorded lecture is literally highlighted by its own color in those readings. So you already did the readings without the color codings. Now what I want you to do is download the readings with the color codings and look at them as you follow along with this video. Every quote I use in this lecture will be color coded, along with some others you'll see, and you'll see why I'm talking about it as I speak in this video. You'll see why I'm talking about it based on its color coding. So go ahead onto classes and download these documents now. So here's the color coding and what it means in those documents. Yellow is for power, which institutions have it and which do not. Light blue is for reason, who has it and who does not have it. Magenta is for superiority, which is superior and who is inferior. And then light green is for time. What comes before what, and why should the precedence of some things matter over others? So what you'll see first about Hamilton is that he is arguing that the Supreme Court should have certain powers to protect separation of powers and sometimes individual rights, but that he's saying that these are limited and they're given to the judges only because they possess calm and deliberate reason and because they protect a constitution that has been sanctified for some reasons that we'll look at by its precedence in time. It came before in time. And Marshall, we're actually going to see in our second video, de-emphasized reason and time in favor of more arguments about power, making the Supreme Court the sole protector of the superiority of the Constitution. So by color-coding those themes, you'll see why it is that I'm saying these documents actually have different meanings to them. They emphasize different themes. You'll be able to see that simply visually by looking at the color coding. Okay, so here's the basic structure of Hamilton's Federalist 78. In the first section, that is pages 1 to 2, he argues that the judiciary is basically weak. But in the rest of the essay, pages 2 to 5, he gives two arguments for why the judiciary is actually strong enough that they can stand up to laws that conflict with the Constitution. And he says this is true in two instances, when the laws might violate express provisions and when they might violate private rights. These are the only two roles that he gives to judicial review. So we're going to cover these in a second. If you don't understand it just yet, hang tight and we're going to get there. So in that first section of the essay, as I said, now it's pretty clear that his opponents fear that judges will be too strong. Since the judges can't be removed from office unless they violate the, quote, good behavior rule in the Constitution, that means they're going to have long tenures in office, even if they make decisions that most people think are just awful. So to the opponents of the Constitution, the anti-federalists, this means that judges will be quite strong, very strong indeed. So the first thing Hamilton does is he positions the good behavior rule as a rule that protects reason. Who could argue against that, right? You'll see he says it's necessary for the responsibility of the judges. You'll see that in one of our blue-coded quotes. To act reasonably in accordance with law, they must be protected from influence by presumably irresponsible forces. And he says there are irresponsible forces out there in the government from which the court will need protection. So what is that force that would undermine the court's responsibility? Well, he says that the good behavior rule is necessary as a defense against the power, yellow-coded, the power of the legislature. So consider this quote from page 1 that's in yellow. In a monarchy, it is an excellent barrier to the despotism of the prince, that is, a court or judicial review is a barrier. In a republic, it is a no less excellent barrier to the encroachments and oppressions of the representative body. So in Federalist 78, the court isn't initially being portrayed as strong. In fact, it's being portrayed as weak in the face of the real strength, which is the legislature. And it needs protection. Its reason needs protection. So Hamilton concludes this argument with a really very famous statement about how weak reason is. You'll find this coded again in light blue on page 1. The court, he says, may truly be said to have neither force nor will, but merely judgment, and must ultimately depend upon the aid of the executive arm, even for the efficacy of its judgment. In our second video on these readings, we're going to continue to look at Hamilton's argument about the dangers posed by the power of the legislature and why reason is a fragile thing that needs protection. And we'll see why he thinks that only the court can actually preserve the superior reason of the Constitution, which is based on the fact that the Constitution, came before any legislative act in time, and it was therefore made at a calmer, cooler, more deliberate moment in time. That is, the Constitutional Convention. Indeed, some people have called this a constituent moment in time. That is, the moment that the American people constituted itself as a people. So come back for our second video, and we'll explore these readings more.